Hello, everyone, and welcome to KE Matters. Hope you're joining us from somewhere nice and cool on this 1st of July lunchtime. Really delighted that we have Paul Roscoe with us today from Appleyard Lees, who's going to give us a very practical session on protecting your AI inventions. Inventions. We're going to do that in quite a practical session, looking at some case studies. Paul's got some questions for you, so do listen carefully and contribute in the chat when you see those questions come in. We've got a session running for about 45 minutes. Paul has some slides. As I say, he's going to talk through some case studies so you can ask questions at any time. The aim of the session is that you have some more insight on what can and can't be patented, and the aim being that you can have better conversations with your researchers and that you can give them the support they need in this relatively new area of IP protection. I'm really, as I say, really delighted that Paul's with us today, and Appleyard Lees provided lots of time for us with their expertise through KE Matters and through our conferences as well. So it's lovely to have you here, Paul, and thank you very much. I will pass over to you.
Thanks, Tamsin. So I'm just going to try and share my slides now. So if I do this and then play from the beginning, is that, Tamsin, that's shared correctly? Yeah? Yeah, good. So as Tamsin mentioned, I am a partner at Appleyard Lees. My area of specialty I'm a patent attorney, and my area of expertise is protecting computer implemented inventions. And in the past 5 or 6 years, that's predominantly meant machine learning inventions. So what I'm going to start with is an overview of the patent system and how that can be used to protect machine learning inventions. And then there are some other forms of IP rights that we can touch on as well. And then I've got 3 case studies that we can go through. So hopefully we get a bit of discussion going there, and we'll just see how long how long those take us to get through. Right, so patentability considerations. So people generally, I'm assuming people here don't really have much experience of patenting AI inventions. Maybe they've come from different areas. AI, machine learning, that seems to have bled into a lot of different industries and subject matters recently. So I'm just going to give you a very high level overview. So no matter where we file a patent application in the world, there's generally speaking 3 hurdles to patentability. The first one is whether it's subject matter eligible. The second one is whether it's novel. That's quite an easy one to demonstrate and to understand. And then there's whether or not it's advantageous. That's inventiveness. Another way to think of an advantage is whether it solves a technical problem. Depending on where you file the application, the bar for, in particular, the first hurdle changes. So what I'm going to just quickly explain is how that varies depending on whether we're filing the application at the European Patent Office, the UK Intellectual Property Office, or other territories, one of the main ones being the United States of America. So at the European Patent Office, the first hurdle is actually quite easy to overcome, as whether it's subject matter eligible. We just have to recite any hardware in the claims. So that could be satisfied merely by writing a computer implemented method in your claim. We then identify the difference for the purposes of novelty, and then we use the problem and solution approach. And this is really where the idea of whether or not people understand, that patents can be granted for whether the invention is technical or not. And that's the point at which this kicks in. So we have to establish whether that feature that's novel solves a technical problem. The term technical has, it depends on which field you're operating in. And then there's not a clear definition. We're really using case law and arguments for that. The UK, the first hurdle is more difficult, so we can't just write a computer implemented method. We need to look at what the contribution of the invention is. So that's more like the inventive concept. For AI inventions, the 2 the two exclusions that could kick in is whether it's a computer program as such or whether it's a mathematical method. And then once we've addressed those, then we move on to novelty and inventive step. Other territories we would look at, so for example, the US, they would look at whether or not the invention's abstract. Now, in terms of anecdotally, a lot of machine learning inventions are generally easier to get protection for in countries like the United States, Japan, Korea. The European Patent Office and the UK are two of the most difficult territories. That doesn't mean we can't do it. What we need to satisfy is the requirement that the application is considered technical. So one of the key things is we can't get protection for core AI inventions. So that would cover like new methods of training a neural network, like different to backpropagation. It would cover different structures of networks without any specific application being tied to it. In the United States, that's a little bit easier to do. In Europe, we can't get away with that. We need to think about what application it's going to be applied to. For example, is it controlling an autonomous vehicle? Is it controlling a robot? Is it machine vision? Is it natural language processing? And each of those applications, some of those are fairly easy to get protection for example, computer vision. Some of them are more difficult, natural language processing being one. So how do we claim this? I mentioned before that we claim it as a computer implemented method. That's to satisfy generally that it's a piece of hardware involved. We claim it as a method because that's usually a bit broader. We don't have to claim it to like a server performing certain parts of the method. And we sometimes try and include a corresponding apparatus claim too. But specifically to machine learning inventions, the difference here compared to, say, just normal computer implemented methods is the fact that we would generally try and claim a method of inference. So that would be using a model to make an estimate, so perform a task. So classifying something in an image, for example. We could then potentially get an independent method for training the model. We could also get independent protection for generating training data used in training the model. When I started doing this type of work on machine learning inventions was about 10 years ago. And then we could get protection if you just claimed that the novel feature was a particular type of model, for example, a random forest, a neural network. That could probably satisfy your novelty requirements. Now we'd probably want to disclose a little bit more. We don't have to disclose the actual weights. We don't have to necessarily disclose the number of layers, the number of nodes, any of the parameter information. But what we would need to do for the European Patent Office, they updated their guidelines. And what we now need to do is we need to explain the training data in more detail so that a skilled person can put this into effect without undue burden. And that's particularly the case where the training data would then affect what the invention is and how you claim it. During the pandemic, I started looking around at the number of patent families filed in a certain classification. So when we file a patent application, the patent office will classify the invention depending on what the subject matter relates to. This is the main classification for machine learning inventions. What I mean by a family is just, so if you file a GB application, we can then file a PCT application, enter the United States, European Patent Office, the Chinese Patent Office. They will all be part of the same family. So we're not number of applications, it's more looking at the number of inventions. During the pandemic, I actually looked at this to see what the actual trend was. And then it looked almost like it was tapering off a little bit. But now, since AI seems to have become very fashionable in the past 2 years with the release of ChatGPT, it seems like that curve didn't actually plateau off like an S curve. It's actually taken off again. So the number of filings has increased further. And one of the things that is important, I think, is to make sure you're filing sooner rather than later, because the amount of prior art now that's out there is huge. I don't know the exact ratio, but the amount of non-patent literature to patent literature, I think it's greater than one. So if this is just the number of patent families, you could imagine how many actual publications are out there for any innovation that includes a component of machine learning. So I'm going to move on to one of the scenarios. So this is an autonomous vehicle example. So the term autonomy stack, I'm going to use that to mean it's one or more models that can control the autonomous vehicle autonomously, so without human intervention. This autonomy stack, I'm going to say, is different to the previous versions because it's end-to-end. Now, what I mean by that, there's various definitions. In this context, what I'm going to say is that we have sensor data as an input and we have control commands as an output. So there's no like rules-based models in between. It's trained on the sensor data, and we have the control outputs as the labels. So one of the major challenges with this approach is the availability of data to train the autonomy stack. So it would take loads of hours. I've put millions there. I don't know exactly what the number would be. In order to experience enough scenarios so the weights are well enough optimized that that it can perform in all situations. Now, even if it does that, it might not actually experience what we call outlier situations or outlier scenarios, edge cases. That would be, for example, where like a child's walking down the road and then all of a sudden jumps into the middle of the road. That probably isn't going to happen in real life, but you want to make sure that the autonomy stack, if it's on the road, can actually respond to that correctly. So to address that issue, what this invention includes is a method of generating some synthetic training data. And in this case, we just said it's using a general adversarial network, a GAN. So what we mean by synthetic is just the fact that it's not real world data. This model has produced something, so it's machine generated data that can then be used to train the autonomy stack. And we can use a combination of those. So the first question, maybe I'll give people a minute to think about it, is what can we protect here using patent protection? So hopefully people, I've just got the chat up.
Yeah, so if you yeah, so this is where we need your input, audience. So hope you've been paying
I mean,
attention.
I can just talk over it and give the answers if people would rather switch
No,
off,
it's
but
fine. I think we have got somebody's Rick Ayler's
the GAN algorithm. Okay. Anybody else? There are several things, by the way. I'm not saying that's right or wrong. So the GAN algorithm, I'll just start with that one to get us moving. So the GAN model. So yeah, we could potentially protect that. Absolutely, yeah, we could protect a method of training. So getting the weights of the GAN, because that's effectively two neural networks. One's a discriminator, one's a oh, I can't remember the other one's called, to determine whether something's real or fake or not. So we can protect that. That's one thing. Anybody else? The autonomy stack, yeah. So we could claim that as an apparatus claim. So we could claim it as, a computer product including the autonomy stack, or the autonomous vehicle including the autonomy stack. We could also claim it as a method, so a method of operating it. So that's inference, I would say. We went back to the three things that we mentioned on one of the previous slides. So we could, a method of using the autonomy stack, we could claim as well. Any more? What about, so if we went back to one of the previous slides, there were three things that we could protect. So one of them was the method of inference. So I think that's what has been suggested there. A method of training, and then we also have a method of generating the training data. So what about those? Does anyone think those might be applicable? Okay, so I think in this example, we would probably claim the method of operating the autonomy stack, we would claim a method of training the autonomy stack using the real world and the synthetic data. We could then claim the method of generating the synthetic training data using the GAN model. I'm just wondering whether there's any other forms of IP rights that might also be used to get some protection here. So I guess this is like a separate question. Database rights, okay, yeah. So I'm assuming that's like an IP right. What would you use database rights or trade secrets? That's another suggestion. What would you use that to what would you use that to protect more specifically? So design rights on where the sensor is. I'm not sure whether that would be I mean, that's thinking a bit outside of this example. I mean, there's probably a lot there, like where the sensor is. Design rights, like to designs, just to be clear, that protects how something looks. There are some exclusions for design rights. For example, must match, must fit. So if it has to go in a specific place, I think we're probably looking more at a patent because that protects how something works. Unless you're looking at the aesthetics of the vehicle and where the sensor might be, then yeah, that could potentially be something we'd look at as well. But I think that's possibly a little bit outside the scope of this. So what about trade secrets? What in here could we protect using a trade secret? Data it's modeled on. The data, cool. So I think what you're mentioning there is the training data, isn't it? So effectively, we don't have to include that in the patent application. So it would remain secret because the patent application is published after 18 months. And if you think about it, you're going to have to include so much training data if you actually want to disclose it all that your patent application is going to be huge and be prohibitively expensive. So that would remain confidential. So that's something else we could do is the actual instances of the data we use to train the model. Anything else that we could look at trade secrets for? No. Well, I mean, one of the things that strikes me, so we have the arrangement of a neural network. It's a lot of hidden layers, and each one has several nodes, and they're all connected in different ways, and they perform computations as it forward passes through the network. When we train it, we end up with a set of weights associated with a weight for each node. We don't have to disclose those in a patent application. We arguably don't even care what the weights are. But if we use a different set of training data on the same structure of a network, we'd probably end up with different weights. So I'll probably say that for trade secrets, we could, we could protect the weight of the model with that as well. I'm surprised no one's mentioned copyright. I mean, copyright's an interesting one. So copyright, if we were, you can get copyright in code, but obviously, like I just mentioned, the weights are, it's not a computer program in the sense of, someone slavishly writes instructions that are executed by a processor. So I'm not sure it would fall under that. I think that would be quite a challenge. I think we've basically got most of those. That's very good. I'm going to move on to the next one. So this one here was it's what we call a sparse neural network structure. So a standard fully connected neural network, it requires a lot of computations during training, and we have this concept called overfitting. So that's where the network, for example, is too deep and it performs extremely well on the data it's given during training, but then if it's seen when it encounters an unseen example, it doesn't perform so well. So this new network, it has a reduced number of connections between the nodes. They're established prior to training, independently of learning, using something called a check matrix. The weights can be used by performing supervised learning. So that supervised learning is just where we give it some training data. We know what the answer is that we want it to produce. We compute a loss, and then we update the weights to reduce the loss. So the network, once it's trained, that can be used to solve a classification problem or a regression problem. So classification is where you get a discrete output. Regression is where you get a continuous output. So property prices, things like that. And the benefit of this is that it can perform classification or regressions without compromising on accuracy. So how can we use the patent system to protect this new network? What do people think? Like what type of claim could we go for first of all? So I think the options for the claim would be the method of inference, method of training, generating training data. So which one of those do people think might be most suitable? Anyone? So I think we could have the method of inference, and we could probably have a method of training as well. One of the other slides that I touched on earlier was the different patentability requirements for each country. So who thinks this, does anybody think this would be patentable at either the European Patent Office or the UK Patent Office? I'm expecting that people will say no, so I'm going to ask a separate question is, why, what might that be? I did give the answer earlier, but I don't know whether it was embedded in other things that I mentioned.
I'm going to take a punt, Paul. I think does it fall into your abstract, that the point about the abstract rather than it being a specific application?
That's exactly it, yeah. So it's relating to core AI, so it's an improvement in the model. It's not pinned, so it says that it can perform regression or classification, but that's not the type of regression or classification isn't mentioned anywhere. So that's exactly right, yeah. So this was actually a European Patent Office case, and they held that it was not patentable, but it actually, the same claims went through to grant in the US, Korea, and Japan. There might have been somewhere else as well. So that's the reason why I included this one, was just to make people aware of the fact that when people are asking for a patentability assessment, so like we're UK and European patent attorneys, that's the type of person you're probably going to be dealing with as your advisors. So we can give you a patentability assessment on that, no problem. When it comes to other territories, we should technically get an opinion from somebody overseas. Even if we don't, it's just worth bearing in mind that you might have some commercial interests in the US, for example. So even if it's not patentable in Europe, it might be worth progressing with and getting valuable protection overseas. There is again this question of So can we obtain protection using any other form of IP right? So what do people think here? Is there anything, could we use a trade secret? What could we use trade secrets for in this instance? Okay, so I think that it's probably going to be very similar to the last example, the matrix. Oh, I mean that's very good. I was going to start off with the weight of the model that we've actually trained. That what you've just said there is really good answer. So I would say the actual matrix. I don't think you need to disclose that in a patent specification. You might need to give some more high-level attributes, but the actual check matrix, the details of it, yeah, absolutely. Protect it with as a trade secret. And one of the things about this is if the interesting thing in this case was there was no examples given. One of the things when we get this type of invention where it's actually fundamental changes to how the model's trained or different network structures, one of the things we try to do is see whether there are any classification or regression tasks that it might likely be used for. For example, if it could well be used for a computer vision task like object classification, then or detecting like blade wear on like a machine. You know, if there are some examples that the inventors intend it to be used for, we probably include those in the description or as a dependent claim. And then we can use the same set of claims for the US, Korea, Europe. We just end up with a different scope of protection. We can file different divisional applications as well for different applications. So I think I'm going to move on to the final one. This one, we've got an ANN, so an artificial neural network, just call it a neural network, for recommending semantically similar files. So recommender algorithms are what platforms like YouTube, Netflix use in order to generate semantically similar content to what you've seen before and basically push you down a rabbit hole that you arguably didn't really want to go down. So they're very powerful. This is an invention where so in this case, we've developed an algorithm which uses an ANN to output relative semantic similarity distance between two input files. We use supervised learning to train the algorithm, including pairs of input files with known semantic similarity distances. So that's your label. We use standard backpropagation and an optimization algorithm to optimize the weights. The files can be any modality. So what I mean by modality is things like video, audio, images, and text. During inference, that's using the model once it's trained. The algorithm obtains relative semantic similarity distances from files in a database to a reference file, and that reference file can be what you have just viewed. And then the distances are ranked, and it then gives you a file, and that's transmitted across a network. Are there any aspects to this that we might want to look at protecting using a patent application? So it's the same sort of things that we looked at in the previous two example. We've got 3 types of claims we can go for. Does anyone think we could try and protect we can make a claim to an inference claim, so using the network? Does anyone think that's a good idea? I see this didn't really work as well as I thought it might. Okay, so if I just go through the answers, so we've got you could potentially argue that you could have a method of inference, you could have the method of training as well. There's no real generation of synthetic training data, so we'll probably forego that claim. one of the key points here is whether or not this is actually protectable in the UK, Europe, or overseas. I included this one very deliberately because this is a case that's currently going through at the UK at the moment. The Patent Office said that this is not patentable. The case was sent to the High Court, then it was appealed. The High Court judge had said that we have to make a division between what's a computer program and what is a machine learning model. So a computer program was defined as anything that a computer programmer sits down, writes the instructions, and then the processor just executes those instructions. With a machine learning model or an artificial neural network in this case, as I mentioned before, the weights are optimized based on the training data. We don't know what they are and we don't really care what they are. But the machine has actually learned how to do this itself. So that's not a computer program by that strict definition. So all the old case law that we had to determine whether or not something was patentable, that wouldn't fall within that exclusion. So therefore, anything involving an artificial neural network would therefore be allowable in the UK. That was quite a controversial decision, considering the UK has always been very strict on what can be patented and what can't be patented. And now it's been appealed to the Supreme Court, and we're waiting a decision on this. So I wanted to flag this because this could, no one knows which way it's going to go. I expect it's probably just going to say it was a rubbish decision, and we're back to where we were. So it's still a fairly strict territory. But I can imagine there's probably like political incentives to go the other way and actually allow more machine learning inventions to be patented, because the government want to make this country like a center for AI innovation, but it's quite a difficult territory to protect your AI inventions. So it would make sense to relax the rules a bit, and this seems like a good way to go. So then we don't have to prejudice any of the previous case law. We can just create some new stuff for machine learning models. I think this case almost certainly will have gone through to grant in the US, irrespective of whether it's a neural network or a computer implemented method. But it is a very interesting case. It's emotional perception AI is the applicant who is involved in this. So it's probably one to have a look at and keep up to speed with. I don't think I've got anything else on this. So I'm just going to open it to see whether anybody's got any questions.
Yeah, thank you very much, Paul. I found that really interesting from a somebody who's never actually had to deal with patents. It was, but aware that this is, AI runs through the new industrial strategy that the government's put out.
Yeah.
There's just made an appointment, I believe, in DSET to lead on AI. This is clearly an area of patenting activity that's just going to keep growing, and we've said before in webinars on AI that this you're kind of always at the frontier, aren't you? You don't quite know what's coming next. There's clearly an awful lot of technical language to be familiarized with. That I can imagine it's very challenging to kind of get up to speed with technical language and with what might be in scope for protection, for IP protection. So it's really useful to have those case studies and hear how you would tackle them and those differences between the various jurisdictions as well. And it's
Yeah.
interesting that point you made about, the role of the ease with which these kinds of inventions can be protected because of
Yeah.
that government incentive, the government push. And there's quite a lot to unpack, I think, about regulation in a broad sense and the industrial strategy and that drive for innovation. So that was, I picked up on that, and that's an interesting one to watch, I think.
No, absolutely, yeah. And I think one of the things I really enjoy about doing this type of work is I just mix with so many colleagues who I never thought I would really have like work with professionally. For example, I've not studied chemistry or maths since I was 16, but now I'm constantly in meetings with our biotech attorneys, trying to help them from the AI, the machine learning
Yeah.
perspective. and learning all kinds of new terms. So it's in some ways it's quite stressful. Um, but in other ways, I just think it's really interesting. It's just something I never thought I would end up doing.
Yeah. Yeah, it's interesting because in in our membership in Knowledge Exchange, the mathematical sciences have really become a much more significant group in our membership, and that disciplinary, um, you know, them thinking about how they can become more active in knowledge exchange, working with industry, but also thinking about how they do approach protection of their intellectual property,
Yeah.
getting much because of the growth of AI, that seeing those disciplines starting to get much more involved, I think much more high profile. So
Yeah.
yeah, we're on a learning curve here, I think.
No, absolutely. And I think there's another thing which I didn't really include, which is all like the proliferation of AI tools.
Mm,
When ChatGPT was
yeah.
released, there are all kinds of companies touting patent drafting tools and patent prosecution
Mm,
tools. So we've trialed some of them. We don't use any as a firm, but we're constantly asked about them because the hope, obviously from clients' perspective, is to reduce costs.
yeah.
Um, and this is something we look at, but we just haven't really found anything yet that is really suitable. It actually takes more time to correct the hallucinations. They all hallucinate, and I
Yeah.
don't know. I don't know where that's going to go, but that'll be an interesting area to watch as well, I think.
Yeah, and that's another. I mean, at our conference recently, we had a few talks. Thinking about how AI could help tech transfer offices, for example, like drafting and just kind of market assessment. But as you say, it's having confidence in what's returned by the model, isn't it? And
Yeah, absolutely. Yeah, yeah.
that's the challenge. So you can't skip the learning yourself. You can't skip that need to understand how the system works so that you can have confidence in the output of a machine generated pattern, I
No,
guess.
absolutely, and also as well. Yeah, someone's just mentioned the
Right,
data
yes.
security. That's a huge thing.
Yeah.
And that's one of the reasons why a lot of the models that people offer to us, we just don't know how they work, and they won't explain it to us. And it's clearly a coincidence that ChatGPT is released, and all of a sudden all these tools are you know being being sold. So
Yeah.
they're obviously leveraging the powerful GPT model in the background. But I think also as well, it's just when you're actually doing this job and you're actually drafting a patent specification, it's not, you don't spend all your time writing. Most of it is dealing with inventors, reading
Mm.
the disclosure, trying to understand how the invention works. You
Yeah.
see what I mean? So the
Yeah.
actual writing is only a small proportion of the time. So you need to still do that bit to check that the output's
Yes.
correct and
And
optimized. And
you're trying to get those scenarios of use, I guess, where you need to have a more specific field of use. You've got to kind of tease that out, haven't you? And think
yeah,
of
exactly.
different scenarios and things. So yeah, no, you're absolutely right. Easy to think it's yeah, just writing a patent, but
Yeah. I've
much more.
also seen some other AI tools, for example, helping inventors write their invention disclosures.
Mm.
Um, I mean, again, obviously the data security point stands. Um, I'm not sure how useful that would be because you'd have to still, if you've got a form to fill out and you can just write your invention into a form, it might make it present nicer, but I'm not really sure of the value of it. I've also seen some other ones where you could take a patent specification and then it could identify certain trade secrets that we mentioned
Yeah,
previously. So, for example, if you had, oh, we're using a model, it would then say, oh, the weights of the model are one of our trade secrets. So it helps you document them, which can be quite powerful for investments. If you're going through funding
right.
rounds.
Yeah.
Um, so
Yeah,
some
I
of
suppose
those
lots of
tools are
these
good.
tools are designed, I've seen examples, yes, of the kind of AI helping with disclosures, and the aim is to kind of save time, reduce burden, I suppose, and make it a kind of fewer barriers to entry for more time-strapped researchers. I guess that is
Yeah,
one of the
true. Yeah.
aims. Reduce burden for smaller TTOs and things, and perhaps to satisfy um, some demands from investors as well for more, um, I suppose, presenting things in a more systematic way or more standardized way. the word I was looking for.
Yeah.
But yeah, there's I think we're still at a very much a proceed with caution stage in this, aren't we?
Yeah, absolutely.
in
Yeah.
Finding the way. Super. We haven't got any more questions in the chat, but thank you to those of you who did contribute to the chat and try and answer Paul's questions. I think that was really useful, and I'm sure when people get the slides and kind of look back through those examples, it'll be really useful to have those reminders and those
Yeah.
prompts, Paul.
And also on that point, it's worth sharing that. So the UK Patent Office, the European Patent Office, and the US Patent Office, they all have examples of, and they're based on cases where they've decided these things are patentable and they're not. So it's worth having a read through those to see if there's anything that's quite similar to what you're looking at.
Yeah, that's really useful. Thank you. I'm sure it's a topic we will keep coming back to, both in webinars and at conference, because as I say, feels like we're something new always happening every day in this area, so always of interest. But thank you very much, Paul. I will let you get back to your day job. Thank you very much for taking the time to join us. Thank you, everybody who came along to KE Matters. And if you're watching the recording, thank you for accessing the recording. I will let you get on with your day. Thank you very much.
Thank you.